Hello everyone. As you have already seen that I have read chapter number 1 and this is chapter number 2 of CPC of CK Takwani, and the chapter number 2 almost contain 105 pages. So the title of the chapter is definition. In general, in most of the statutes, a section provides for definition of some important expression used in the body of the act. A definition clause is a sort of a statutory dictionary, a legislative device with a view to avoid making different provision of the statute needlessly cumbersome. After that, I'm thinking after reading this, I must go to the park so I can at least walk for a while. So, cumbersome, where a word is defined in a statute and that word is used in a provision to which that definition is applicable. The effect is that wherever the word defined is used in that provision, the definition of the word gets substituted. This normal rule may be departed from if there be something in the context to show that the definition should not be applied, or when the context strongly suggests its departure. Important definitions. Section 2 of the Code of Civil Procedure, inter alia, the following important definitions are given. First, decree, meaning the adjudication of a court of law may be divided into two classes, decree and order. Section 2, subsection 2 of the code defines the term decree in the following words. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determine the rights of the parties with regard to all or any of the matter in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and determination of any question within section 144, but shall not include any adjudication from which an appeal lies, as an appeal from an order, or B, any order of dismissal for default. Explanation: a decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary and partly final. Essential elements. In order that a decision of a court may be a decree, that the following elements must be present. First, there must be an adjudication. Second, such adjudication must have been done in a suit. Third, it must have determined the right of the parties with regard to all or any of the matters in controversy in the suit. Fourth, such determination must be of a conclusive nature. And fifth, there must be a formal expression of such adjudication. First, adjudication. For a decision of a court to be a decree, there must be an adjudication, that is, a judicial determination of a matter in dispute. If there is no judicial determination of any matter in dispute, it is not a decree. Thus, a decision on a matter of an administrative nature, on an order dismissing a suit for default or appearance of parties, or dismissing an appeal for want of prosecution, cannot be termed as a decree in as much as it does not judicially deal with the matter in dispute. Further, such judicial determination must be by a court. Thus, an order passed by an officer who is not a court is not a decree. Second, suit. The expression suit is not defined in the code, but in Hansraj Gupta vs. Official Liquidators of the Dehradun Mussoorie Electric Tramway Corporation Limited, the Lordships of the Privy Council have defined the term in the following words. The word suit ordinarily means, and apart from some context, must be taken to mean a civil proceeding instituted by the presentation of a plaint. Thus, every suit is instituted by the presentation of a plaint. It means that when there is no civil suit, there is no decree. Thus, rejection of an application for leave to sue in forma pauperis is not a decree, as there is no plaint till the application is granted. It may, however, be noted that under certain enactments, specific provisions have been made to treat applications as suits. For example, proceedings under the Succession Act, the Hindu Marriage Act, the Land Acquisition Act, and the Arbitration Act, etc. There are statutory suits, and the decisions and the decisions given thereunder are therefore decrees. Therefore, a proceeding which does not commence with a plaint and which is not treated as a suit under any other act cannot be said to be a suit under the code also, and the decision given therein cannot be said to be a decree under section 2 subsection 2 of the code. Thus, a decision of a tribunal, even though described as decree under the act, is a decree passed by a tribunal and not by a court covered by section 2 subsection 2. Third, rights of parties in controversy. The adjudication must have determined the rights of the parties with regard to all or any of the matters in controversy in the suit. The word rights means substantive rights of the parties and not merely procedural rights. Thus, rights of the parties inter se relating to the status, limitation, jurisdiction, frame of suit, accounts, etc., and the right of the parties under this section. The rights in matter of the procedure are not included in it. Thus, an order for dismissal of a suit for default of appearance, or an order dismissing an application for execution for non-prosecution, or an order refusing leave to sue in forma pauperis, or a mere right to sue are not decrees, as they do not determine the rights of parties. The term parties means parties to the suit, that is the plaintiff and the defendant. Thus, an order on an application by a third party who is a stranger to the suit is not a decree. In interpleader suits, the contesting defendants will be deemed to be parties to the suits. The expression matter in controversy refers to the subject matter of the suit with reference to which some relief is sought. At the same time, however, it should not be understood as relating solely to the merits of the case. It would cover any question relating to the character and status of a party suing, to the jurisdiction of the court, to the maintainability of a suit, and to other preliminary matters which necessitate preliminary matters which necessitate an adjudication before a suit is inquired into. Interlocutory orders on matter of procedure which do not decide the substantive right of the parties are not decrees. Similarly, the proceeding preliminary to the institution of a suit also will not be included in the definition. Fourth, conclusive determination. Such determination must be of a conclusive nature. In other words, the determination must be final and conclusive as regard the court which passes it. Thus, an interlocutory order which does not decide the right of the parties finally is not a decree. For example, an order refusing an adjournment, or an order striking out defense of a tenant under the relevant Rent Act, or an order passed by the appellate court deciding some issues, remitting other issues to the trial of for determination under Order 41, Rule 23 of the Code, are not decrees because they do not decide right of the parties conclusively. On the other hand, an order may determine conclusively the right of the parties, although it may not dispose of the suit. Thus, an order dismissing an appeal summarily under Order 41 of the Code, or holding it to be not maintainable, or a decision dismissing a suit for want of evidence or proof are decrees in as much as they decide conclusively the right of the parties to the suit. The crucial point which requires to be decided in such a case is whether the decision is final and conclusive in essence and substance. If it is, it is a decree. If not, it is not a decree. Fifth, formal expression. There must be a formal expression of such adjudication. All the requirements of form must be complied with. The formal expression must be deliberate with and given in the manner provided by law. The decree follows the judgment and must be drawn up separately. Thus, if a decree is not formally drawn up in terms of the judgment, no appeal lies from that judgment, but the decree need to be in a particular form. Thus, a misdescription of a decision as an order which amounts to a decree does not make it less than a decree. Test whether or not an order of the court is a decree. The court should take into account pleadings of the parties and the proceedings leading up to the passing of an order, which with a view to find out the meaning of the words in the order and to determine whether such order is a decree. The court often may have to consider the circumstances under which the order was made and the words are used. Decisions. D. Decisions which are decrees. Illustrations. The following decisions are held to be the decrees. First, order of abatement of suits. Second, dismissal of appeal in as time barred. Third, dismissal of suit or appeal for want of evidence or proof. 4. Rejection of plaint for non-payment of court fees. 5. Granting or refusing to grant costs or installment. 6. Modification of scheme under section 92 of the code. 7. Order holding appeal non-maintainable. 8. Order holding that the right to sue does not survive. 9. Order holding that there is no cause of action. And 10. Order refusing one of several reliefs. E. Decision which are not degree. Illustration. The following decision on the other hand are held not to be degree. First, dismissal of appeal for default. Second, appointment of commissioner to take accounts. Third, order of remand. Fourth, order granting or refusing interim relief. Fifth, return of plaint for presentation or to proper court. 6. Dismissal of suit under Order 23, Rule 1. 7. Rejection of application for condonation of delay. 8. Order holding an application to be maintainable. 9. Order refusing to set aside sale. 10. Order directing assessment of Mesne profits. F. Classes of decrees. The code recognizes the following classes of decrees. First, preliminary decree. Second, final decree. And third, partly preliminary and final decree. In Sankar vs. Chandrakant, the Supreme Court stated a preliminary decree is one which declared the right and liability of the parties, leaving the actual result to be worked out in further proceedings. Then, as a result of the further inquiries conducted pursuant to the preliminary decree, the right of the parties are fully determined and a decree is passed in accordance with such determination, which is final. Both the decrees are in the same suit. A final decree may be said to become final in two ways. When the time for appeal has expired without any appeal being filed against the preliminary decree or the matter has been decided by the highest court. Second, when as regard the court passing the decree, the same stands completely disposed of. It is in the latter sense that the word decree is used in section 2 subsection 2 of the CPC. First, preliminary decree, where an adjudication decides the right of the parties with regard to all or any of the matters in controversy in the suit but does not completely dispose of the suit, it is a preliminary decree. A preliminary decree is passed in those cases in which the court has the first to adjudicate upon rights of the parties and has then to stay its hands for the time being until it is in a position to pass a final decree in the suit. In other words, a preliminary decree is only a stage in working out the rights of the parties which are to be finally adjudicated by the final decree. Till then, the suit continues. The court provides for passing of preliminary decrees in the following suits. First, suits for possession and Mesne profits, Order 20, Rule 12. Second, administration use suits, Order 20, Rule 3. Third, suits for preemption, Order 20, Rule 14. 4. Suits for dissolution of partnership, Order 20, Rule 15. 5th, suits for accounts between principal and agent, Order 20, Rule 16. 6. Suits for partition and separate possession, Order 20, Rule 18. 7. Suits for foreclosure of a mortgage, Order 34, Rule 2 to 3. 8. Suits for sale of mortgage property, Order 34, Rule 4 to 5. 9. Suits for redemption of a mortgage, Order 34, Rule 7 to 8. The above list is, however, not exhaustive, and a court may pass a preliminary decree in cases not expressly provided for in the code. Question. There is a conflict of opinion as to whether there can be more than one preliminary decree in the same suit. Answer. Some high courts have taken the view that there can be only one preliminary decree in a suit, while other high courts have held that there can be more than one preliminary decree. As regards partition suits, the debate is concluded by the pronouncement of the Supreme Court in Fulchand vs. Gopal Lal, wherein it has been observed that there is nothing in the Code of Civil Procedure which prohibits passing of more than one preliminary decree. Its circumstances justify restricted to partition suits, as the courts specifically observed. We should, however, like to point out that what we are saying must be confined to partition suits, or for For we are not concerned in the present appeal with other kinds of suits in which preliminary and final decree are also passed. The question whether a decision amounts to a preliminary decree or not is one of the greatest significance in view of the provision of section 97 of the code, which provides that where any party aggrieved by a preliminary decree does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. Since the passing of a preliminary decree is only a stage prior to the passing of a final decree, if an appeal preferred against a preliminary decree succeeds, the final decree automatically falls to the ground for there is no preliminary decree thereafter in support of it. It is not necessary in such case for the defendant to go to the court passing the final decree and ask it to set aside the final decree. Second, final decree. A decree may be said to be final in two ways. First, when within the prescribed period no appeal is filed against the decree or the matter has been decided by the decree of the highest court, and second, when the decree so far as regard the court passing it completely disposes of the suit. It is in the latter sense that the word final decree are used here. A final decree is one which completely disposes of a suit and finally settles all questions in controversy between parties, and nothing further remains to be decided thereafter. Thus, in a suit of recovery of money, if the amount found due to the decree holder is declared and the manner in which the amount is to be paid has also been laid down, the decree is a final decree. Sincerely, a decree passed for a sum representing past masonry profit and future masonry profit at a particular rate without directing any further inquiry is a final decree. Thus, where a decree passed by a special court did not contemplate any further proceedings, the decree, even though described as a preliminary decree, in substance was a final decree. Ordinarily, there will be one preliminary decree and one final decree in one suit. In Gulusam BV versus Ahamadasana, Ahamadasa, Rauthar, Gulusam BV versus Ahamadasa Rauthar. The High Court of Madras, referring to rule number 12 and 18 of order 20 of the code, stated neither rule contemplates more than one preliminary decree and one final decree in one suit. In fact, the code nowhere contemplates more than one final decree in one suit. To have two final decree and to call the first one a final decree will be a really misnomer, as it will not be final. In Kasi versus Ramanathan Chetiyar, the same court considered the question as at considerable length. It was noted that there was divergence of opinion whether there could be more than one preliminary decree as also more than one final decree in a suit. Then, considering the question in detail and describing the observation in Gulusam Bibi versus Abhitar Dicta, the court observed that there could be more than one preliminary decree and more than one final decree in a suit. Patanjali Sastri, justice as he then was, rightly concluded the matter thus. The question is not whether the court allows more than one preliminary decree or one final decree to be made, but whether the court contains a prohibition against the court in a proper case passing more than one such decree. Finally, in Shankar versus Chandrakant, the Supreme Court said it is settled law that more than one final decree can be passed. It is settled law that more than one final decree can be passed. Third, partly preliminary and partly final decree. A decree may be partly preliminary and partly final. For example, in a suit for possession of immovable property with masonry profits, where the court first decree possession of the property and B direct an inquiry into the masonry profit. The former part of the decree is final, while the latter part is only preliminary, because the final decree for masonry profits can be drawn only after inquiry and the amount due is ascertained. In such a case, even though the decree is only one, it is partly preliminary and partly final. G. Deemed decree, meaning the term deemed is generally used to create a statutory fiction for the purpose of extending the meaning which it does not expressly cover. In CIT versus Bombay Trust Corporation, the Privy Council stated when a person is deemed to be something, the only meaning possible is that whereas he is not in reality that something, the act of parliament or the legislature requires him to be treated as if he were. Second, nature and scope. Whenever the legislature uses the word deemed in any statute in relation to a person or thing, it implies that the legislature, after due consideration, conferred a particular status on a particular person or thing. Such statutory fiction created by the legislature cannot be ignored. The effect of such legal fiction must be given. In East End Dwellings Co. Limited versus Finsbury Borough Council, Justice rightly said the statute says that you must imagine a certain state of affairs. It does not say that having done so, you must cause or permit your imagination to boggle when it comes to the inevitable corollaries of that state of affairs. 3. Decree and deemed decree distinction and adjudication not fulfilling the requisites of section 2 subsection 2 of the code cannot be said to be a decree. By legal fiction, certain orders and determination are deemed to be decrees under the code. 4. Deemed decrees under CPC. The rejection of a plaint and determination of question under section 144 restitution are deemed decrees. Similarly, adjudication under order 21 rule 58 as also under order 21 rule 98 or 100 are deemed decrees. H. Rejection of plaint. Even though an order rejecting a plaint does not preclude the plaintiff from presenting a fresh plaint on the same cause of action, section 2 subsection 2 of the code specifically provides that the rejection of a plaint shall be deemed to be a decree. The rejection of a plaint must be one authorized by the code. If it is not under the code, the rejection will not amount to a decree. An order returning a plaint or memorandum of appeal to be presented to the proper court is also not a decree. The reason is that such an order does not negate any rights of a plaintiff or appellate and is not a decision on the rights of the parties. An order returning a plaint to be presented to the proper court in an appellate order, in an appealable order. The question whether an order is one of rejection or of dismissal of a suit or appeal must be determined with reference to the substance and not the form of the order. First, restitution. The determination of any question within section 144 of the code is expressly included in the definition of decree, though such determination is neither made in a suit nor is it drawn up in the form of a decree. Section 144 deals with restitution and determination of a question under that section and is included in the definition of decree for the purpose of giving a right of appeal. Every order under section 144, however, is not a decree. It is necessary that such order must be decided the right of the parties with regard to matters in controversy in proceedings under that section. In other words, it must be a final decision either granting a relief or refusing an application. Thus, determination of a mere issue made prior to the passing of a final order or an order merely determining a point of law arising incidentally in the course of proceeding for determining rights of parties is not a decree. J. Execution. Prior to the Code of the Civil Procedure Amendment 1976, the determination of any question under section 47 was also expressly included in the definition of the decree. The Joint Committee of the both House of the Parliament was of the view that that this provision was mainly responsible for delay in execution of decrees. The committee therefore recommended to omit word section 47 or from the definition of decree, and as such, now a decision under section 47 is not a decree and consequently is not appealable as a decree. Under the new code, now it will not be very difficult for the decree holder to get the fruits of a decree passed in his favor. It is, however, doubtful whether the amendment has achieved its object or not. K. Dismissal for default. The definition of a decree does not include any order of dismissal for default. The definition of decree does not include any order of dismissal for default. The word dismissal for default include for want of prosecution of suit or appeal, default for non-appearance or for other reasons. Appealable orders. The term decree expressly includes an adjudication from which an appeal lies as an appeal from an order. Such orders are specified in section 104 and order 43, rule number 1 of this rule 1 of the code. Thus, an order returning a plain for the presentation of the proper code, or an order rejecting an application for an order to set aside an ex parte decree, or setting aside or refusing to set aside a sale under order 21, or an order rejecting an application for permission to sue as an indigent person, an indigent person, maybe पागल व्यक्ति नहीं, जो दिमाग से ठीक नहीं है, जिसका दिमागी संतुलन ठीक नहीं है. सो एज एन इंडिजेंट पर्सन. इंडिजेंट पर्सन क्या होगा? इज इट वर्किंग? लेट मी चेक व्हाट्स द मीनिंग ऑफ इंडिजेंट. Oh, I'm so sorry. It means निर्धन व्यक्ति. That was insane. A insane person. And this is indigent. Indigent is निर्धन व्यक्ति. So where we were? Refusing to set aside a sale under order 21, or an rejecting an application for permission to sue as an indigent person. कोर्ट फीस पे करनी होती है ना, तो उसके लिए अगर कोई indigent है तो उसको person etc. are appealable orders and not decrees. The distinction between a decree and an appealable order lies in the fact that in the case of a decree, a second appeal lies in some cases, but no second appeal lies from an appealable order. Decree and judgment distinction, and decree and order distinction. Decree and deemed decree distinction. Now we will see the where is it, we will see the differences in between, and where I gonna find it. What is 53? Hello. Where will I find the chart of 53? Oh, this is the issue. C infra. What would be the meaning of C infra? Infra कहाँ है इसका भाई? इंफ्रा किसे कहते हैं? इंफ्रा जी, वेयर आर यू? सेकंड अपील. Subject index. What does the meaning of C infra? See below. It's a Latin term used in legal academic writing to refer to a later point in the same document, indicating that further detail or information are presented below the current point. I didn't able to find out where the differences are, so let it be. Fourteen. It's been half an hour. I'm. It's been 4 o'clock. Still 5 minutes left. It's what I can say. It's 5 to 4. So I will leave at 5:30, 4:30 for for the walk thing. Uh, should I continue? Because I have already finished the 10 pages, and before it we read 14 pages in chapter number 1, and in chapter number 2 we have already read the 12 pages. We have read up till yet 12 pages. Okay, let's continue. This is judge. Second is judge. Judge means the presiding officer of a civil court. The term court has not been defined in the code. According to the dictionary, meaning court means an assembly of judge or other person acting as a tribunal in civil and criminal cases. In other words, it is a place where justice is judicially administered. Where justice is judicially administered. When a statutory provides that a particular matter will be determined by a court, the officer presiding over the said court will be deemed to exercise jurisdiction as a court and not as a persona designator, but by the mere fact that under the relevant statute some functions are to be performed by a judicial officer, it cannot be said that he is acting as a court. Third, judgment. A, meaning. Judgment means the statement given by a judge on the judge of the grounds of a decree or order. B, essentials. The essential element of a judgment is that there should be a statement for the grounds of the decision. Every judgment other than that of a court of small causes should contain first a concise statement of the case. Second, points for determination. Third, the decision thereon. And fourth, the reason for such decision. A judgment of a court of small causes may contain only points. Second and third, sketchy orders which are not self-contained and cannot be appreciated by an appellate or revisional court without examining all records are therefore unsatisfactory and cannot be said to be judgments in that sense. As the Supreme Court in Balraj Taneja versus Sunil Madan, a judge cannot merely say so decreed or so dismissed. The whole process of reasoning has to be set out for the deciding the case one way or the other. Even the small causes court's judgment must be intelligible and must show that the judgment has applied in his mind. The judgment need not, however, be a decision on all the issues in a case. Thus, an order deciding a preliminary issue in a case, for example, constitutional validity of a statute, is a judgment. Conversely, an order passed by the Central Administrative Tribunal cannot be said to a judgment, even if it has been described as such. Similarly, the meaning of the term judgment under the letters patent is wider than the definition of the judgment under the CPC. See, judgment under the degree. Okay, got it. See, judgment under the degree distinction. As stated above, judgment means the statement given by judge of the ground of a decree or order. It is not necessary for a judge to give a statement in a decree, though it is necessary in a judgment. Likewise, it is not necessary that there should be a formal expression of the order in the judgment, though it is desirable to do so. Rule 6A of Order 20 is as inserted by the Amendment Act of 1976, however, enacts that the last paragraph of the judgment should state precisely the relief granted. Thus, a judgment contemplates a stage prior to the passing of a decree or an order, and after the pronouncement of the judgment, a decree shall follow. Fourth, order. A, meaning. order means the formal explanation of any definition of a civil code which is not a decree. Thus, the adjudication of a code which is not a decree is an order. As a general rule, an order of a court of law is founded on objective consideration, and as such, the judicial order must contain a discussion of the question at issue and the reasons which prevail with the court which led to the passing of the order. B. Order and decree similarities. As discussed above, the adjudication of a court of law may either by a decree, or B, an order, and cannot be both. There are some common elements in both of them. This first, both relate with the matter. Both relate to matter in controversy. Second, both are decisions given by a court. Third, both are adjudication of a court of law, and fourth, both are formal expression of a decision. C. Order and decree distinction. You know what was the meaning of infra? It means to see below, and I was looking up like the page has been ended, and now where I have to see the below thing, and then I found the same thing like it meant to see further, like when you flip up the page. So I got the distinction between the judgment and decree on the next page. See, order and decree distinction. In spite of above common elements, there are fundamental distinctions between the two expressions. First, a decree can only be passed in a suit which commenced by presentation of a plaint. An order may originate from a suit by presentation of a plaint, or may arise from a proceeding commenced by a petition or an application. Second, a decree is an adjudication conclusively determining the rights of the parties with regard to all or any of the matter in controversy. An order, on the other hand, may or may not finally determine such rights. Third, a decree may be preliminary or final, or partly preliminary and partly final, but there cannot be a preliminary order. Fourth, except in certain suits where two decrees, one preliminary and the other final, are passed, in every suit there can be only one decree, but in the case of a suit or proceeding, a number of orders may be passed. Fifth, every decree is appealable unless otherwise expressly provided, but every order is not appealable. Only those orders are appealable as specified in the code. Sixth, a second appeal lies to the High Court on certain grounds from the decree passed in first appeal. Thus, there may be two appeals, while no second appeal lies in case of appealable orders. Fifth, decree holder. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. From the definition, it is clear that the decree holder need not necessarily be with the plaintiff. A person who is not a party to a suit but in whose favor an order capable of execution has been passed is also a decree holder. Thus, where a decree for a specific performance is passed, such a decree is capable of execution both by the plaintiff as well as the defendant, and therefore either of the parties is a decree holder. Similarly, if a decree confers upon someone a right to execute the decree, he is a decree holder. Conversely, if in an eviction order, time to vacate the premises is granted to the tenant, the landlord cannot be said to be a decree holder in the strict sense till the period is over and the decree become executable. Sixth, judgment debtor. Judgment debtor means any person against whom a decree has been passed or an order capable of execution has been made. Where a decree is passed against a surety, he is a judgment debtor, within the meaning of this section. On the other hand, a person who is a party to a suit but no decree has been passed against him is not a judgment debtor. 7. Foreign court. Foreign court means a court situate outside India and not established or continued by the authority of the central government. Two conditions must be satisfied in order to bring a court within the definition of a foreign court. First, it must be situated outside India, and second, it must not have been established or continued by the central government. Thus, courts in England, Scotland, Ceylon, Burma, Pakistan, and those of the Privy Council are foreign courts. 8. Foreign judgment. Foreign judgment means a judgment of a foreign court. The crucial date to determine whether the judgment is of a foreign court or not is the date of the judgment and not the date when it sought to be enforced or executed. Thus, a judgment of a court which was a foreign court at the time of its pronouncement would not cease to be a foreign judgment by reason of the fact that subsequently the foreign territory has become a part of the Union of India. On the other hand, an order which was good and competent when it was made and which was passed by a tribunal which was domestic at the date of its making and which could at that date have been enforced by an Indian court does not lose its efficacy by reason of the partition. I didn't understand this, so I have to read this one more time. Foreign judgment means a judgment of a foreign court. The crucial date to determine whether the judgment is of a foreign court. The crucial date to determine whether the judgment is of a foreign court or not is the date of the judgment and not the date when it is sought to be enforced or executed. Thus, a judgment of a court which was a foreign court at the time of its pronouncement would not cease to be a foreign judgment by reason of the fact that subsequently the foreign territory has become a part of the Union of India. Time of its pronouncement would not cease to be a foreign judgment by reason of the fact that subsequently the foreign territory has become a part of India, Union India. On the other hand, an order which was good and competent when it was made and which was passed by the tribunal which was domestic at the date of its making and which could at that date have been enforced by the Indian court does not lose its efficacy by the reason of the partition. Basically is saying कि अगर किसी फॉरेन कोर्ट ने जजमेंट दी है और बाद में वो जो फॉरेन कोर्ट है वो इंडियन टेरिटरी में आ जाती है तो वो उसको वो जो है वो उसकी जजमेंट है वो स्टिल फॉरेन जजमेंट ही मानी जाएगी, वो इंडियन टेरिटरी में फॉल नहीं कर जाएगी क्योंकि जो डेट है जजमेंट का हमें वो देखना पड़ेगा. अगर उसके बाद जो है अगर वो उसके बाद भले ही एग्जीक्यूशन हो रहा हो और इंडिया में वो आ गया हो तो उसको इंडियन कोर्ट एज एन इंडियन कोर्ट काउंट नहीं होगा, वो एज एन फॉरेन कोर्ट ही काउंट होगा. तो जो डेट है जजमेंट का वो हमें देखना पड़ेगा टू डिटरमाइन वेदर इट इज़ फॉरेन कोर्ट और नॉट. 9. Legal representative. Legal representative means a person who in law represent the state of a degree person and include any person who intermeddle with the state of the deceased and where a party sues or is sued in a representative character, the person on whom the state devolves on the death of the party so suing or sue. This is the page number 30. The expression legal representative is inclusive in character. Its scope is very wide and thus over and above a person who in law represents the state of a deceased. It include a person who intermeddle with the state. I should take at least 2 to 3 minutes break because I just diverted my mind somewhere. I got a message from a counselor and I saw that message popped up on my phone and then I got distracted. So let me read what the message is. I have been a judiciary aspirant myself in the past, but I can vouch for one thing. Litigation has taught me skills that I know will help me in clearing judiciary if I decide to do if I decide to do it any day. I have been a judiciary aspirant myself in the past, but I can vouch for one thing. Litigation has taught me skills. Okay, got it. No issues. I would strongly recommend that you take up the course and Actually, I am in a dilemma. So that's what I am discussing with my mentor, uh, who used to teach me, and that's what I am discussing regarding the thing. And the person is guiding me like, oh, like a family member. So I just got the person's message. Mm, Such an emotional message. Come on, come on, come on. Yeah. It's been 1 hour. We still have 15 minutes. So we were on point number 9, legal representative. A legal representative means a person who in law represent the estate of a deceased person, and include any person who intermeddles with the estate of the deceased and where a party sues or is sued in a representative character. The person on whom the estate devolves on the death of the party so suing or sued. The expression legal representative is inclusive in character. Its scope is very wide and thus over and above a person who in law represent the estate of a deceased. It includes a person who intermeddles with the state of a disease, and also a person on whom the state devolves on the death of the party suing or sued, where a party sues or is sued in a representative character. The following persons are held to be legal representative: executor, administrators, reversioners, Hindu co-partners, residuary legatees, etc. But a trespasser is not a legal representative, as he does not intermeddle with the intention of representing the state of the disease. Similarly, an executor, deedson, taught a succeeding trustee, official, assignee, or receiver is not a legal representative. I must read it once again. A legal representative. I have understood this portion. And where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of the party so suing or sued. The expression legal representative is inclusive in character. Its scope is very wide and thus over and above a person who in law represent the estate of the disease. It include a person who intermeddle with the estate of a disease, and also a person on whom the state devolves on the death of the party suing or sued, where a party sues or is sued in a representative character. The following persons are held to be legal representatives: executor, administrator, reversioners, Hindu co-partners, residuary legatees, etc. But a trespasser is not a legal representative, as he does not intermeddle with the intention of the representing the state of the deceased. Similarly, an executor, deedson, taught, a succeeding trustee, official, assignee, or receiver is not a legal representative. Mesne profits meaning. Mesne profits of property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profits, but shall not include profits due to improvements made by the person in wrongful possession. The object. Every person has a right to possess his property, and when he is deprived of such right by another person, he is not only entitled to restoration of possession of his property, but also damages for wrongful possession from that person. The missing profits are thus a compensation paid to the real owner. The object of awarding a decree for missing profits is to compensate the person who has been kept out of the possession and deprived of enjoyment of his property, even though he was entitled to possession thereof. C. Against whom missing profits can be claimed. Wrongful possession of the defendant is the essence of a claim for missing profits and the very foundation of the defendant's liability. Therefore, as a rule, generally a person in wrongful possession, against whom missing profits can be claimed. My mind became like a, what we say, numb. Now it is not. My mind is not able to take all these things, so I just forgetting from here like since 5 to 10 minutes. Wrongful possession of the defendant is the essence of a claim for the missing profits and the very foundation of the defendant's liability. Therefore, as a rule, therefore, generally a person in wrongful possession and enjoyment of immovable property is liable for missing profits. It is very clear that missing profits can be claimed with regard to immovable property only. Thus, a decree for missing profit can be passed Okay. A person in wrongful possession and enjoyment of immovable property is liable for mercenary profit. It is very clear that mercenary profit can be claimed with regard to immovable property. Mercenary profit. Okay. Thus, a decree for mercenary profits can be passed against a trespasser or against a person against whom a decree for possession is passed, or against a mortgager in possession of mortgage property after a decree for foreclosure has been passed against him, or against a mortgagee in possession of property even after a decree for redemption is passed, or against a tenant holding over at will after a notice to quit has been served upon him, where the plaintiff is disposed. What's Where the plaintiff is disposed by several persons, every one of them would be liable to pay mercenary profit to the plaintiff, even though he might not be in actual possession or the profit might not have been received by him. The court in such cases may hold all the trespassers jointly and severally liable, leaving them to have their respective rights adjusted in a separate suit for contribution, or may ascertain and apportion and approach the liability of each of them. The assessment. Mercenary profit being in the nature of damages, no invariable rule governing their award and assessment in every case can be laid down, and the court may mud it up according to the justice of the case. In assessing the mercenary profit, usually the court will take into account what the defendant has gained or reasonably might have gained by his wrongful possession of the property. The test to ascertain mercenary profits is not what the plaintiff has lost by being out of possession, but what the defendant gained or might reasonably and with ordinary prudence have gained by such wrongful possession. Test. The test to ascertain mercenary profits is not what the plaintiff has lost by being out of possession, but what the defendant gained or might reasonably test. The test to ascertain mercenary profits is not what the plaintiff has lost by being out of possession, but what the defendant gained or might reasonably and with ordinary prudence have gained by such wrongful possession. Not coming in my mind. The test to ascertain mercenary profit is not what the plaintiff has lost by being out of possession, but what the defendant gained or might reasonably and with ordinary prudence have gained by such wrongful possession. Nice point. I could be missed this point if I would have not read it more than once. F. Principle. The following principle would ordinarily guide a court in determining the amount of mercenary profit. The following principles would ordinarily guide a court. The following principles would ordinarily guide a court in determining the amount of mercenary profits. Already finished up the 30 pages, almost 31 pages. It's being 4:30. Now I will come at least 6:30. Then I will start studying. Okay, have a good time.